All right, so once again, we welcome everyone to the Election Petitions Special 233 Street Laws Initiative. It's episode 3, and I'm joined again by my friends, Yauswa Bebio, 233 Street Law crew member, Yao Atakra Kweku Atakra Jomo, legal practitioner, and Mr. Ebo Asredu, law student from Wisconsin University. My name is Jeffrey Osei Mensah, and we're glad to be back in your homes once again. And so, topic of discussion for this episode, we are looking at the empanelment of the bench, empanelment of judges to sit on the presidential election petition. We want to first and foremost establish who has that power, who is responsible for the bench that we have seated on this election petition. We'll also look at the allegations of bias here and there, and we'll look at contempt of court. And so we start empaneling judges to sit on this presidential election petition. Atakra Abebio, whose primary duty is it? Who has that power? Does the president influence that in any way? Do parliamentarians influence that in any way? Basically, does anyone have any influence on the empanelment of judges to sit on a particular matter? What do we have to say to this?
Okay, well, I'll say that to empanel justices to sit on a matter is it lies within the power of the Chief Justice.
All right.
The Chief Justice under our laws is the one who has the power to determine which judge will sit on any matter for any case.
Okay.
So, with the election petition in question, for instance, the Chief Justice who will determine which judges will sit on the matter. So, it's the Chief Justice who determines that Judge A, Judge B, Judge C, you sit and hear those matters, and no other person.
Okay.
That part to empanel the justices, you can draw it from the whole concept of separation of powers. Now, the judiciary is a distinct arm of government from the executive or from the legislature, of which how the chief justice will do his job cannot be questioned, let's say, by even the president.
Okay.
So that's a discretionary power given to the chief justice.
Okay.
So if the chief justice decides, as I think parties A, B, and C should sit on the matter, that is, let me say, semi-final, because parties may have the right to challenge that decision. The party, so let's say in the election petition, the petitioner or the respondent may have the right to say that, my Lord, the Chief Justice, we have a problem with this particular justice sitting on it. And if you check it, you'll see that even before the empanelment was done, a few petitions were sent to the Chief Justice that the Chief Justice should consider and determine that this particular justice should not sit on the matter or should not hear the matter, and they advance their reasons. I mean, whether it's going to be valid or not, the Chief Justice will determine. And we can see that now the petitions that people made, the Chief Justice took some of them into consideration when he was empaneling the courts. So some of the names that came up in the petitions, those people did not appear on the panel.
Okay.
Of which, I mean, ordinarily we could have said that they would have come because of their experience. But because there's a public outcry, the Chief Justice decided to probably just take them out and just maintain some other justices to hear the matter. So to answer it in just a single way, the Chief Justice has that power.
Okay. So then we're saying Justice Kwesi Eni-Yeboah then is the one who's has that statutory power to empanel the judges to sit on the election petition. He himself is also on that panel, and so he selected himself to also sit on the election petition. But
Yes.
it's his administrative function, and so to not do so would be shirking his responsibility as the Chief Justice. Yeah, so I think that should be well established to the understanding of all. Now let's move to the panel itself as it is now. Okay, so I'll quickly run us through a list of the present Supreme Court justices, and the requirement under the Constitution is that at every given time there shouldn't be less than 9 justices of the Supreme Court, and so there isn't really a cap on the number of Supreme Court judges that should exist in Ghana. Okay, And so let me just run us through it. Of course, we have the Chief Justice Kwesi Eni-Yeboah. All right, he was appointed in 2008 by then President His Excellency John A.J. Kufuor. We have Justice Jones Doche, also appointed in 2008 by John Kufuor. We also have Paul Bafo-Boni, who was also appointed in 2008 by John Kufuor. And so Eni-Yeboah, Justice Doche, as well as Bafo-Boni happen to be, let me say, mates at the Supreme Court. Then you also have Justice Yao Ampao and Justice Gabriel Puaman, who are appointed by John Mahama. Okay. And then you have Justice Mafo Sao, Justice Agnes Doji, and Justice Professor Niashi Kote. You also have Justice Nene Amegache. You also have Justice Mariama Owusu, Justice Avro Lovelace Johnson, Justice Tokonu, Justice Amadou, Justice Onyenuga, Justice Mensah Bonsu, and then Justice Kulendi, all appointed by Nana Addo Akufo-Addo. All right. Now, if you notice, of the list I've mentioned, just 2 out of the list were appointed by John Mahama or the NDC government at some point in time. The rest have been appointed by MPP governments. Okay. Now let's juxtapose that with the panel that we have. We have presiding over the election petition, Justice Eni-Yeboah, of course, he's the Chief Justice. You have Justice Ampao, you have Justice Mafo Sao, you have Justice Amegache, you have Justice Professor Kote, you have Justice Owusu, and Justice Tokonu. All 7 of these justices happen to be justices appointed by the MPP president at some point in time. So either John Kufuor or Nana Addo Akufo-Addo. People have raised some allegations of possible bias here and there, or because you are appointed by the MPP government, then you may seek to do serve their interests whilst you're on the panel. Atakra Abebio, what's your take on this? Because I mean, we know that there's a law governing bias and all of that, but what's your take on all of that? Do you think these comments are justified? Abebio.
Okay, so maybe I reiterate what Kuku said, in that the power to empanel judges is done by or under the authority of the CJ. And the Constitution, fortunately or unfortunately, doesn't recognize or doesn't take into consideration whichever administration or government appointed which CJ or which justice. The duty of the justices of whichever courts or whichever judge is to administer this justice. Okay, and they are supposed to do it fairly, candidly, uphold the law, and at the end of the day, ensure that the matter is properly determined between the parties. So, and the fact is that they are human beings. It's human beings who are supposed to sit on the matter. We can't get angels or whichever extraterrestrial beings to do that. Now, I think over the years, the courts in Ghana have done a very, very good job. When I say courts, I mean the judges have done a very good job in administering this justice that we want, regardless of likely political intimidation or whatever personal interest or influence. I think they've done a very good job in doing this. So I think that these allegations in a human situation, we should expect them. Yes, there are fears and things like that, but I don't think that they are founded, especially from the point of the Chief Justice, the courts it's themselves, not only in Ghana, but in other places across the world, especially those that share the same legal system as Ghana, have said that this administrative duty of the Chief Justice, he cannot delegate it. He cannot give it to anybody else. He is the head of the judicial arm of government. So he is the one supposed to do it. regardless of what pertains in it, is at play. He's the one supposed to empanel justices, or the empaneling of justice is supposed to be done under his authority. So everything is attributed to him. This concern that, okay, there's been a precedent in 2013 where the Chief Justice appointed a panel, but chose not to be part of the panel. And rightly so. It's within her discretion, the former Chief Justice Georgina Wood. Now, in this particular situation, Justice Enini Yeboah has decided that he wants to be a member of the panel. I think that we should respect the judicial arm of government and accord them with that respect, in that they have, over the years, done justice to whatever dispute has come before them. And we should be very, very careful with the allegations that we level against them, regardless of whichever walk of life we find ourselves, be it lawyers, non-legal persons, members of parliament, members of government. I think we should be very careful.
Sorry, Atagra, let's move into the law, okay? I've introduced the whole concept of bias, and we know that our jurisprudence or the laws of Ghana isn't new to that concept of judges being biased. There's some standard of proof that should be established in order for you to conclude that somebody is going to be biased, okay? I believe what we are dealing with now is a scenario where you have judges appointed by a particular person who is also a party to the election petition, okay? What would your response be to these allegations as far as the law governing bias is concerned?
Okay, thank you. And I'll take off from where Abibio left off. He made an important point about the former Chief Justice, that's Justice Georgina Wood, regarding the 2012 election petition where she decided not to sit. Now, that instance was quite interesting, because even for that, she decided herself was not going to sit, because she had openly declared that I think he used to fellowship with the president, that's Dramani Mahama. So it felt like she has a closer relationship with him, that she just doesn't want to cloud her judgment in any way. So she recused herself, right? And now that brings us to the whole concept of the law on bias. Now, the truth of the matter is that judges are bound by their judicial oaths. And if you look at our system currently, now people are more literate. So a lot of people even read the judgments, even more than even we lawyers. And for them, to their lay mind, the way they understand it, they critique the judges now even more than lawyers. I mean, now lawyers barely even write articles critiquing judgment. The lay people go on the radio and they're able to dissect it. So for now, if you check it now, even the judges, they are very careful with their rulings, because they know that it's to the world at large, not just to lawyers. Now, I'm very careful, and I'm quite worried when people make these statements about this president appointed this person, or that person appointed that person. Yes, the president is just like saying that President President Nana Addo Kufuor was voted into power by people who believe in NPP ideals or NPP people. So when he comes into power, he only does projects for NPP people. So such that if I live in a place where, let's say, I voted for John Dramani Mahama, because I didn't vote for Kufuor, when they construct a road, when they get to the front of my house, they'll stop it and jump to the next person. It's neither here nor there. Anybody who comes into a public office, you are there for everybody. And so with the Chief Justice or other justice, even if they are appointed by the president, they come in to do justice, not to do the bidding of the president. And as I mentioned earlier, thankfully, their judgments are written and published. So if they decide to take a particular side, the whole world will see that, okay, this judge, this is what he's doing. And for them, and if you check with Supreme Court justices, what matters a lot to them is their integrity. At least if you've dealt with a few of them, I mean, most of them, they have made all the money they can make in their life. They are not now coming to make money. What they deal in is their integrity, and of which I know they don't play with it at all. Yeah. Now, some time ago, I think His Lordship Justice so it's
VRAC crap.
VCRAC crowd.
Yes.
VCRAC crowd of Blessed Mary, may so rest in peace. He made a profound statement which I always thought about. And he was like, one thing we also don't appreciate is that judges are human beings. Judges relate with people just like any other person, but they have a conscience of which they exercise it in law, of which outside their personal relationship with people, they know when they sit in the chair, they know that they're sitting as an arbiter, as a neutral person. And they've been trained so much so to do. Now he was like, when we start making allegations every time that this judge is biased, this judge is biased, what you do is that you make judges move out from the public domain and they are recused from the public domain. What that will mean is that they make decisions which the public can relate with because they themselves can relate to the public. Because if he goes for this function and he's seen there, the next thing he sits on the panel, definitely one person or the other will appear for him to say he'll be biased. So now he stopped going to church. I think he mentioned a few justices where they have stopped going to church because they feel like their church is a large church. Definitely somebody from there will come to his court. Then now he can't hear the case. So I rather recommend to people that the law on bias within our law is very high. That you must prove a real likelihood of bias. Now that means that we we have some level of trust to give to our judges that they will do justice to the matter. So it's only when it has crossed that high threshold where we say no, for this we are very sure that the judge will be fair, then we'll decide that we are going to change him. But merely saying that the president appointed him, because most of them also were due for promotion. Some of them had been at the court of appeal for a very long while. If you even take Justice Niashikote, he had been in the public service probably for over 30 years. He had taught the law for over 30 years. So there's a person who is well qualified to be a justice. So if it happens that within his tenure, or even take Professor Mensa Bosu, I don't think she's on the panel, but there's a person who is well respected across the world. So I don't think if it's her time and Nanado Danko has appointed her, she's going to say because Nanado appointed me, I'm going to give him I'm going to just cast my support in my vote in support of him, even when I think he has no case. I don't think it's founded because these people out there, I think they are people of integrity. And I don't think merely saying that this person appointed is going to change their decision now.
You mentioned this phrase, the real likelihood of bias. Real likelihood of bias. It simply means, to my understanding, that it shouldn't just be a mere suspicion because so far, yes, you've been appointed by one of the parties as a Supreme Court judge, or you've been appointed by John Kufuor, who was the president under the MPP ticket, as a Supreme Court judge, and so we suspect that you will be loyal to them, and as such, you are going to cast your vote in the determination of this matter in their favor. I mean, that then is a mere suspicion, but the threshold being a real likelihood of bias, you should be able to point out to certain facts, certain occurrences that lead to that conclusion that your neutrality has been compromised to some extent. All right. And again, Ebo, I'll take your comment on this point I'm about to put across. At every given time, a Supreme Court judge is appointed by a president. There's no doubt about it. Okay. And so I don't know whether it would be right to fault a particular judge for being appointed by a particular president at a particular time. All right. Because I don't think that the argument would have been the same if majority of the panelists were judges appointed by John Mahama.
But I'm sure if it had been the case, then the respondents would have been complaining.
Would have argued.
They would have been, they would have complained
but Ebo, I'm coming to you. All right. We've read out a list of Supreme Court judges, and of this pool, there are only 2 judges currently sitting in the Supreme Court who were appointed by John Mahama. Okay. And so it simply means that, like it or not, even if those 2 judges appointed by John Mahama were to be appointed or empaneled to sit on this election petition, it would still be a majority of 5-7. Would the argument still be the same that we are outnumbered?
personally, I think there's a bigger issue at play here, and it borders on the lack of trust that the Ghanaian people have in government. We all know the judiciary is one of the three arms of government. So we don't trust our parliamentarians. We think they are just in parliament chopping our money. We don't trust the executive. We think the president has how do you call it, family and friends government that is perpetuating a form of family business aimed at enriching just a few people. And that same sentiment also exists for the judiciary. And it wasn't helped by analysis expose. So there's a lot of lack of trust from the Ghanaian people towards government. So because of this lack of trust, anything that can be used in this argument gains traction. So the fact that Mr. Mahama appointed just a few justices is now an issue. But maybe it's because I'm a student of the law. But anytime I come across a Supreme Court ruling, I'm impressed by the way they think. And as lawyer pointed out, they are really invested in their integrity. So I'm not saying as an authority that all Supreme Court rulings were right or without bias, no. But I'm saying that to some extent, they have the capacity to give rulings without being biased. So I think we should all just allow them to do their way. That's
yeah, but in Ebo's submission right now, I want to highlight something.
Yeah.
Well, there's a claim of a lack of trust in government as a whole, supposedly, and the judiciary being a third arm or one of the arms of government. But the thing is, how come, or I don't think that this issue of bias ever arises in any dispute or form of litigation, whether in the Supreme Court or in any other court, except when it's an election petition. How is that? Because we hear threats of "I'll sue you, I'll send you to court." People do trust the judicial system in Ghana. I think so. So how come it's only when it reaches presidential elections that we all seem to bring this?
I'll play the devil's advocate here and say that, I mean, when you talk of political cases, okay, this is as political as any case can be. This is a suit to determine whether a president who has run under the ticket of a party was validly elected by a nation. And so I would say, I mean, this whole talk of this, that bias and all of that, it's to be expected, because this is the highest form of a political case that you can come across, you know. And so, I mean, if people then start to
agreed,
yeah, if the argument of lack of trust comes in and all of that, I believe it's just to substantiate some of these positions that people will take, because it's a highly political case.
Yeah, I agree on that point, but there are different or lower levels or lower degrees of political cases, or cases which have some political inclination. But a lot of times we do see that the Supreme Court, despite all these factors being at play, justices being appointed by certain governments, they give rulings which do not necessarily favor that those allegations of bias. It was in July of 2020 that that's with respect to the Sao case, yes, the EC was given certain orders. I mean, we may attend to that in subsequent episodes, but you can see that there are different levels of political cases, not only at the presidential, but the justices, I would strongly argue that they do not do anything which feeds into these allegations of bias.
So in other words, people should look at their track record as far as political cases are concerned, and allow that to inform their opinions at present. and not necessarily just take the present
Exactly.
and then start making reference to such allegations. I think the point has been
Yeah.
very well made. But before we move on, back to the point I raised, okay, Ebo Ataka, there's a situation where of the pool of Supreme Court judges, pool of Supreme Court judges, we have a majority of MPP appointed judges and a minority, a drastic minority, that's two justices appointed by the NDC. Now, this is through no fault of anybody. It simply happens that prior justices of the Supreme Court had reached retirement age. They had to retire. There were vacancies. And so judges needed to be appointed. And it so happened, coincidentally, that those retirements took place, or majority of those retirements took place during 2016 to 2020. And it meant Nana Addo Dankwa was saddled with that responsibility of appointing justices. And so in a case like this, even if someone argues that, look, make sure that the panel is balanced, okay? How do you go about something like this? If you were Justice Eni Eboa, and there were calls that, look, appoint a panel that is balanced. We want NDC balance. How would you go about it without having a majority of so-called MPP appointed judges as against a minority of NDC judges?
No, but you see, because as you mentioned, when it took us to the justices in the Supreme Court, I think we were kind of the only two who are appointed by the NDC government, right?
That is so.
So if, let's say, yes, so if it's empaneling seven, I mean, there's at least going to be 5 supposed NPP appointed judges and 2 NDC appointed judges. It still comes back to the same problem.
Yeah.
So it probably shows that, yes, there's a problem of which at this point is beyond the Chief Justice.
Exactly.
All he can just do is to trust the integrity of the judges. And you see, I think that there's the team of the petitioners, because they realized that to make an argument that their NPP or NDC appointed judge may not fly because of this too. I read some time ago about the fact that now they were complaining not about who appointed, but about their experience. So they were like, the Chief Justice left out the more experienced judges and took on the newer ones. I mean, that's just still making the arguments, but from a different angle, which I think is still neither here nor there.
Yeah, because every judge is competent. I mean, yes, there may be differences in the number of years served at the Supreme Court, but every justice is competent basically, and so that's another way to look at it. And I feel, I mean, yeah, through dialogues like this, discussions like this, members of the general public should advert their minds to this perspective of discussions. Quickly, we'll touch on contempt. 2013 petition, a number of people were cited for contempt. They appeared before the Supreme Court. Sir John of blessed memory happened to be one of them. Aikwe had to bail him out before the Supreme Court, and a number of others. What's contempt? What should people look out for? What should they be careful not to do in order not to be cited for contempt in this election petition process? Abibiu.
Okay, so contempt. It can be before the courts or outside the courts. So when we talk of contempt, it means you've disrespected the court, or you brought the authority of the court into disrepute, disrespect at the end of the day.
Yeah.
There are lots of things that could get one into those shackles of contempt.
Yeah.
But I think in terms of advice or the things that could that could get someone into these shackles.
Yeah.
I think a lot of times is about someone's speech. Is not a lot of actions, but it's about someone's speech. So on the media, whether print, audio, visual, saying things which bring the authority of the court into disrepute or to disrespect the authority of the court is what will get you into these hot waters.
Yeah.
So that is what you are supposed to stay clear of. Be sure that your utterances or what you put out, whether it's articles, text, or your speech, is or does not bring the authority of the court into disrepute. That's
So in
my
other
summary
words,
or my take
so,
on
so,
it.
so in other words, you're not saying people shouldn't comment on proceedings. Okay, they shouldn't share their take, but they just need to be circumspect of I mean the nature of these comments. Because then if they are directed at undermining the authority of the judiciary or getting people to believe that the judiciary is probably biased or incompetent or anything along those lines, then you may be entering into the arena of contempt. Atakra Ebo, very quickly, what's your take on this? I mean, as far as contempt is concerned, what do you think people should be careful not to do? Yeah, either Atakra or Ebo.
Okay, do I take it first? Or
Yes,
okay,
yes.
let me take it
Atakra,
first.
then you go
Okay,
ahead.
so as Abibu has said, contempt, anything you are saying that's going to bring the court and the image of the court in disrepute, that you're going to reduce the image of the court or bring it into disgrace.
Mm,
And also to mention that anytime a judge sits, the judge does not sit in his or her personal capacity. The judge sits as the court. So when people insult the judge, what essentially you are doing is that you are insulting the court. And the law won't allow anybody to insult the court. So for me, and I appreciate that these cases are they are cases where the tensions are high. Personal interest or vested interest, of which I'll advise that if you're going on the radio, you're on TV, you are writing on social media, be careful what you write. You can comment objectively, you can comment based on law, but for people to, like, even if you take even the recent Muntie 3, for instance, some of the kind of things people say against the judges, they are very unpalatable statements that even something that lawyers can't save you. And coming from 2012, we've learned our lessons from 2012. 2012, we are not seeing any of the election petition any as this kind. So we could understand some of them. But now we've had the opportunity of seeing one, and it's been about 8 years now. We've learned our lessons. So the social commentators, the political commentators,
the
we
bloggers.
advise them, the bloggers, yes, we advise them to very circumspect. Don't allow anybody pay you to do, because it's possible you might have been, some might have been jailed for 3 days, and contempt, there's no cut on even how many days you can be jailed. You can even be sent in for years. And you may not have anybody to come and bail you out. And you've been sentenced by the Supreme Court. At least if it was the High Court, you could have probably appealed. But the Supreme Court, where are you appealing to? So you probably be there. So I think our advice that people should just be careful in what they say. Because the tensions are high, and the least you may say, they may put you before the court for
Exactly.
contempt.
Exactly. Ebo, any comments, remarks on this matter?
I think my seniors have said everything. So it's the same thing. That when commenting on this issue, it should be done with care. We should be responsible in our comments. I like tweeting something. Tweet like you have sense. I think this particular moment is the moment for that. Tweet or comment, talk, write your blog like you have sense. That's all.
Sure. Interesting points made there. And let's also bear in mind, I mean, the judges are human beings. They have feelings, they have emotions. And so, I mean, if you take to the airwaves, you take to your page on social media and you are insulting, look, they are not robots who do not have emotions. They may act on those emotions, and inciting you for contempt, you may be slapped with a very hefty punishment. So bear that in mind as we journey through these times. 233 Street Law will keep updating you on the election petitions series, progressing with what's happening in the Supreme Court, as well as the High Court's parliamentary election petitions as well, bringing you up to speed and up to date. So do well to tune in to our subsequent episodes. And again, I'm very grateful, Ebo. I'm grateful, Kufuor, Atakra, Jomo, Abebio. It's been great having you guys.
Yeah.
So we'll catch you guys later. Enjoy.